Caroline Wilson. I'm an associate at Collier, Walsh, Nakazawa, and today we're here to talk about a recent Ninth Circuit opinion that came out in Ray Grand Jury. The case came before the Ninth Circuit, was decided in 2022, so just a few months ago, and it was discussing which privilege test should apply to dual-purpose attorney-client communication. So we're mainly talking about our in-house counsels, general counsels, who often communicate with their client and provide both legal and non-legal advice, i.e. business advice. So attorney-client privilege protects confidential communications between attorneys and clients, which are made for the purpose of giving legal advice. You can imagine a situation where an attorney helps their client prepare tax returns. This is solely a business function, and therefore it's not going to be privileged because it's not considered a situation where an attorney is rendering legal advice to their client. But that same attorney may then offer legal advice to their client to figure out what to claim on a tax return, and in this instance, this is legal advice, and it may be protected by attorney-client privilege. So the Ninth Circuit was faced with two different tests to apply. There's the primary purpose test and the because of test. The primary purpose test just looks to, is the predominant purpose of the communication to render or solicit legal advice. The because of test is traditionally used in the work product doctrine. It's a little bit broader, and it's mainly looking to, or mainly requires just a causal connection between the creation of the work product and anticipated litigation, regardless of what that primary purpose is. So put another way, the document or communication would be created because of anticipated litigation, and would not have been created but for the prospect of litigation. So it's much more broad than the primary purpose test, and it's just looking for that causal connection. So the court, or the Ninth Circuit, ultimately held that the primary purpose test was going to be applied to dual purpose attorney-client communication. And the court reasoned that the policy goals behind protecting attorney-client communication and attorney work product were much different, so it didn't make sense to apply the same test for both. And again, the because of test is traditionally applied to the work product in the work product context. So attorney-client privilege exists for the purposes of protecting attorney-client communication, and the policy behind it is to promote frank and honest communication between the attorney and client, so the attorney can render effective and informed legal advice regardless of anticipation of litigation. So again, that purpose is to give legal advice. Work product privilege exists to preserve an attorney's privacy so they can best prepare and develop legal theories and strategy in anticipation of litigation. So the privilege works to protect the lawyer's strategy and legal theories free from intrusive adversaries who might use the discovery process to pry into the litigator's mind. So in addition to the court choosing the primary purpose test to support the underlying policy behind protecting attorney-client communications as privilege, the court added an additional reason, and they pretty much declined to adopt the broader because of test out of fear that it would incentivize corporations to add an attorney at every layer of a business decision in an attempt to shield disclosure of certain communications and documents, just because an attorney was there, and just because an attorney could say, well, we communicated or created this document because we were concerned about potential litigation. Hopefully this information was helpful, and if you have any questions, feel free to contact us at cwn-law.com. Thanks so much.